On Monday, the Supreme Court said states can require presidential electors to vote for the candidate who won the state's popular vote. It's upholding state laws that punish so-called faithless electors. The court examined the votes of electors in the 2016 election from Colorado and Washington state. The ruling comes just months ahead of this year's general election. For more on this, let's bring in CBS News legal analyst Kim Wehle. She's also the author of the new book, What You Need to Know About Voting and Why. Kim, nice to see you again. So the Supreme Court was unanimous in this ruling. Justice Elena Kagan wrote for the court, quote, "The Constitution's text and the nation's history both support allowing a state to enforce an elector's pledge to support his party's nominee and the state voter's choice for president." What is the significance of this ruling?
The significance of this ruling is to make very clear that the voting process in the United States really boils down to what states want. So if a state were to say to its electors, if you do not vote according to the popular vote that decides whether the votes will go to a Democrat or a Republican slate, if you don't do that, we will fine you. In this instance, it was up to $1,000 fine. The Supreme Court said not only can states basically tell their electors how they must vote in the Electoral College, but they can fine them if they don't comply with what the state wants. And so what it basically means is electors can't sort of go renegade and decide we are going to exercise our own discretion to cast our ballots in a way that's inconsistent with the popular vote of that particular state.
Well, what was the argument against laws punishing faithless electors?
Well, the argument was really a historical one. The idea that for many, if you look back in time, there's one instance, I think, where it was, a serious defection. There have been times where electors have said, we have exercised our own discretion. We can change our minds and do it the way we believe it should be done. And I think the argument goes to why would we have an electoral college if there weren't some level of discretion there. The problem is that the 12th Amendment changed the Constitution when it comes to the Electoral College and essentially baked into the system the two-party system without using those words. But essentially, the original Constitution allowed the electors to choose their top two candidates for president, and that didn't work historically. There was a couple ties that were problematic. And so the framers changed it and said, listen, we will allow the states to decide on the president, the ballot for president, and ballot for vice president. And basically, most states say if 51% of the vote goes for the Republican nominee, then all of the electors will go and vote according to the Republican Party's platform. Likewise, if 51% of the voters go for the Democratic nominee, then all of the electors will vote according to that party's platform. The wrinkle really here is, and the court only mentions this in a footnote, there are two states, Maine and Nebraska, which have decided, no, we don't want all the electors to go to whoever won 51 or more percent of the vote. They split it. They do proportional voting. So 51% might go to a Republican, and the other 49% of the electors would go to a Democrat. And there are a lot of people in this field, in the electoral field, that think that is a better way for states to divide up their electors because it's more consistent with the popular vote. A lot of people are upset about the Electoral College because we've seen multiple instances in history where the electoral vote is not consistent with the proportional vote, or the popular vote. But that really boils down to how the states tell their electors to vote in the Electoral College. And what this decision says is, guess what? The states get to decide that. So if voters don't like it, the answer is to go to their state legislators and say, we want you to tell you the Electoral College voters, or the electors, to vote differently in our state.
And Kim, how many states have laws like this?
Well, as the Supreme Court noted, 20 to 30, I can't remember the exact number, have the requirement that electors actually vote according to the popular vote. Only about 15 have a penalty. The Supreme Court had previously already held that states can dictate how electors can vote. But the question really here was, can the state also impose a penalty against electors if they don't vote consistent with what state law tells them to vote. And as I said earlier, the contrary argument is these are human beings. They should be allowed to make their own decisions as electors. The court rejected that. Reading the plain language of the Constitution said, listen, Article 2, when it talks about the Electoral College, is really vague. It's very open-ended. There's no mandate that limits the state's authority to dictate how the electors actually have to vote.
Well, Kim, the Supreme Court still has a few other big cases to hand down. What are you watching for this week?
Well, the big one really has to do with the subpoenas for the president's tax returns. This is not the first case this term that deals with the question of the power of the presidency. We saw one last week in which the court struck down the creation of the Consumer Financial Protection Board as having a single head that could not be removed by the president. These are issues that prior to Donald Trump, frankly, most people didn't really follow. The question of how the government is structured, those constitutional issues. Most people really worried about the Bill of Rights, the First Amendment, Second Amendment. But under Donald Trump, what is really at stake in the election and in these cases is how much power should be concentrated in the office of the presidency without oversight from the other branches of government. And the reason it's so important is this is about changing the office itself. So if Joe Biden were to win in November, the office of the presidency itself gets more power. And those are the kinds of questions, I think, that are really critical. And we'll have to see whether the president can basically continue to withhold information from various requests from other parts of government with impunity. This president has essentially said, not only is the information that is created while I'm in office cannot be turned over, but anything relating to my personal life and my family and my businesses also cannot be turned over. And I think, myself included, other scholars would say, listen, presidents are there at the will of the people. They serve the people, and the people can't make good decisions about the job that any president is doing without information. Government in the sunshine is really important. Sunshine's the best disinfectant. That's really a basic concept of any good system of government, any good system in your schools, your churches, corporate governance. We have to know what people with power are doing with that power so that we, the people, can decide if we like it or if we want a different person in office. And that's not only at stake in these Supreme Court decisions, but that's really at stake in November. And that's why I wrote the book. I mean, we, the people, need, regardless of who you vote for, to show up at the polls, to try to vote by mail, ask for your absentee ballot now, because at stake in November is whether we will have a government going forward where the people really direct their elected leaders, not the other way around. Historically, this is a red light moment for democracy itself in that regard. So as much as these Supreme Court decisions are important, I think as a constitutional scholar, more important is to get as many people to the polls, regardless of political party, that are eligible to vote in November. And that's a real challenge in a pandemic.
Absolutely. All right, Kim Wehle, great to have your insight. Thank you.
Thanks, Elaine.